I want to go right to what went zeitgeist across this nation yesterday. Professor Feldman's Bloomberg opinion column, which summed up some of the emotion. We'll get to Cass Sunstein in a moment. The worst decision since the infamous Korematsu case, when the court upheld the internment of Japanese Americans during World War II. These efforts are far too little to save the court or Justice Kennedy from the judgment of history, which will be harsh. Chief Justice Roberts also takes the opportunity to announce that Korematsu, quote, was gravely wrong the day it was decided and has been overruled in the court of history. Greg, will this court decision stay? Will it stick? Or is there room to move here where it will be overruled? And we're looking at Noah Feldman's classic book on a tumultuous court of another time scorpions. What's going to happen 2 years, Greg, 5 years down the road?
Well, it looks like, at least with this court, it certainly has some staying power, Tom. The majority really didn't seem like it had that much trouble with this case. It basically, Chief Justice Roberts and the other conservatives looked at the federal immigration laws. They said that they give the president very broad discretion to limit who can come into the country. And they said, when we're talking about a claim that he's violated the Constitution, we're not going to deeply second-guess his national security judgments. Here, they had a legitimate national security interest, and that was enough for the majority.
Right. Let's look at Cass Sunstein now, of course, out of Chicago. His wonderful recent book on impeachment. Here's Cass Sunstein on the 92 pages, the multiple diverse opinions extending to 92 pages. Chief Justice Roberts repudiated Korematsu, as Professor Feldman told us. Justice Kennedy's words are pathetic. And then I thought this was fascinating, Greg. Justice Breyer's quiet commitment to reason-giving and the rule of law, has a claim to stand among the most distinguished dissenting opinions in the history of the Supreme Court. What did the quiet Breyer, what did he say?
Well, interestingly, so there were two dissents. One was from Justice Sotomayor, who invoked Korematsu and said the opinion was a lot like Korematsu. And then there was Justice Breyer, who was focused on a lot of the practicalities of this. And he said the biggest problem he had, or a big problem he had, was that the system is supposed to have an ability to get case-by-case waivers for people who don't have any, pose any national security threat, who have an urgent need to get into the country for medical care or something like that. And he said, it's not clear to me that that system is working, that anybody has given guidance to consular officers on how to let people apply for case-by-case waivers. And so what he really wanted to do was to kick the case back to the lower court and say, let's make sure this system actually works.
Will that happen? To me, the essence of this transaction, this legal moment, this, go back to Roe v. Wade 73 or Brown decades before that, is what happens, Greg, operationally tomorrow or in 2022 off of Trump v. Hawaii? Operationally, what happens?
Well, operationally, the administration has very, very broad discretion. Justice Breyer, who's often a bridge builder on the court, he and Justice Kagan, who joined his opinion, are two of the justices who try to look for ways to compromise and bring in some of their conservative colleagues, but they didn't. The majority opinion, as I said, says the president has very broad discretion, and they weren't willing to take that step that Justice Breyer said. They weren't willing to force the administration to come back and defend itself in terms of how it's allowing those individual waivers.